right. I'm Max Levine. I'm a lawyer. My office is literally right on top of me. I deal with small businesses, creators, and internet startups. My goal tonight is basically two things, maybe three things. One is I want to make sure you guys have a clear understanding of your rights and the assets that you're producing. The second thing is I want to make sure that everybody's thinking of themselves as creating property that you own. Okay, you can choose to do what you want with that property, but you own it. And a lot of times people that I see think of themselves as providing a service. No, you're creating property, and that's yours. Okay. And the third thing is I want to get you guys paid. There are situations with your clients, and there are situations with third parties that I talk to a lot of content creators where they're not getting paid as much as they should be in those situations. So those are essentially the three things we're going to talk about. I can start my presentation. I always have to say, I'm a lawyer, I'm not yet your lawyer, so this is a broad overview of copyright as it applies to creators. It's not legal advice, except for register your work. That is legal advice, go do that. You're gonna hear me say that 50 times, okay? The best decisions depends on the facts, so we're not making any legal choices right now. A little bit about me, I'm gonna skip this. I'm a lawyer, super nerdy, got 2 law degrees, worked for a federal judge in DC, Juan Vasquez, the nicest guy on the planet. Worked for a large law firm defending Fortune 500 clients and international performers, mainly in tax issues. Now I work with small businesses, and you guys are all small businesses. If you're an entrepreneur, if you're creating content, you are a small business. So I do contracts, intellectual property, that's what we're talking a little bit about tonight. I work on tax issues, employment law, and corporate and securities work. So what's the point? Tonight, I want to make sure that you guys have a clear understanding of your rights. I want to encourage you to register and keep an eye on your work. I want to clarify your agreements with your clients, and I want to get you paid if someone's violating your rights, okay?
Before you go on, I just want to
Sure.
check on something. RJ, just for clarity, are we sitting in a great collection so you get the video content, or do we need to shift up any, like anything? Are we good? Yeah. All right, I just tried to think of it like such a small, close-knit group. Make sure you got a good angle there.
I'll tell you what, David, I'm actually really happy you asked that because you reminded me to ask some questions as well. Let me just poll you guys. So number one is, has anybody here ever registered a copyright of their work? Okay, David has. Anybody else? It's okay if you haven't. Most people have not. Have you ever seen a client misuse your work? Okay, so you had, yeah, RJ? Yeah, okay. So you use it beyond the scope of what they were paying you to do. Whatever it is, yeah. That's a big yes from. That's a big yes from a couple of you. Okay. Has a client ever not paid a bill? That's the guys. Yeah. Okay. A little hesitant from Raul. Have you ever seen a third party, somebody you never dealt with, using an image or content of yours in ways that you did not give them permission to? That can include reposting it on Instagram, whatever it is. Okay.
Newspapers, magazines.
Okay. So we're going to talk about important and actually fairly straightforward ways to address some of these issues and to get you paid when some of these things happen. Okay, that's really kind of the takeaway is copyright allows you to get paid when these things happen. Okay, so we're going to talk about what your rights are, registering your work. You're going to hear me say that word register a million times. How to use that C symbol. What to do when people misuse your work, aka get paid, making money from your clients, and then a quick note on things that I get a lot of questions about, which is Instagram, social media, and the DMCA. You got those takedown notices. We'll talk about those really, really quick. Should be about 35 minutes or so from here. Welcome, welcome. How you guys doing? Hey, all right, all good. All right, so let's start with basically fundamental background in copyright law. Okay, so this is the super boring stuff, but it's kind of the bedrock of what we're talking about the whole night. Copyright is an intellectual property right. It protects an original work of authorship that has been fixed in a tangible medium of expression. So what does that mean? It means a specific thing. Okay, so you have different types of intellectual property. You have like a patent, right? A patent means it's a concept. I got an idea that nobody else has. I have a business process that nobody else has. It doesn't need to be a thing. It doesn't need to be a picture. It doesn't need to be a book. It's a broad conceptual idea. I can protect that, okay, as an intellectual property right. But a copyright is in a specific thing, okay? It can be a digital image. It can be a book, a manuscript. It can be a play. But it is a specific thing. And we're going to talk about how specific it has to be. one of the most dangerous facts, probably the most dangerous fact about copyright, is the one that everybody knows. So as soon as you click the shutter, as soon as you hit record, you own the copyright to that image, that video. As soon as you start writing, you own the copyright to that manuscript. But that right is essentially useless until you register it at the US Copyright Office. And I'm going to get into the details of that. It's a really important thing that I want everybody to take home. So yeah, you do own the copyright, but it's not that useful. So what does copyright protect? It's actually not one thing. It's called a bundle of rights, okay? So you get the exclusive right when you have the copyright to reproduce that work, to adapt it, to distribute it, to perform it, obviously a little bit less relevant for AV, to display it, and to import it. We're not going to talk about importation, super complicated. An important thing is how long does this right last? Generally speaking, RJ takes a picture, okay? So he owns that right for the rest of his life plus 70 years, okay? So now think about how important that could be. Instead of just getting paid from the client that you took that picture for, right? If you give that client a license, we'll talk about that later, but you still own the rights to that, that becomes meaningful 65 years after you pass away. Your grandkids are getting paid for it, okay? That's how long copyright lasts. And that's why I want you guys to start thinking about yourself as producing property and not just doing a service for a client, okay? So what's up, David?
I got a million questions, but I'll start with a simple one. I don't want to distract your presentation.
Sure.
How long after you've produced the work are you allowed to register it? Is it a year, a month, 10 years?
You can register it whenever. The most important thing to do is to register it as soon as you create it, because then any infringement thereafter, after that point, is easier to sue. Bottom line is, if you register it after 5 years, the law does change a little bit. Okay, they can start questioning whether it's really your image. But if you register it immediately, that's your greatest protection. But you can register older stuff. If it was created before like 1979, there's different laws that apply to it, but those are only relevant to like some of us. So yeah, you get those 6 exclusive rights. That's what you start with. You can slice them, you can dice them, you can sell them, you can rent them, but those are the rights that are included in copyright, and they last basically for your life plus 70 years. Okay, that's a big deal. What's up, David?
Follow-up question.
Yeah.
If you get hired to do work, does this still apply?
Yes, and we're going to talk about that. We're going to talk about that. What we're talking about is, I'm losing the words. We're going to talk about it for sure, though. Okay, so big question. So is this an infringement? The original image is on the left, okay? First one taken. I'm going to butcher this guy's name, Lewis. We'll just call him Lewis. Okay, he takes this picture. Sometime after that, Lee takes the picture on the right, okay? They're taken separately. So is this a copyright infringement? Anybody want to guess?
I would guess no, because Lee created his own version.
Because Lee...
What was inspired by Lewis's work.
Could be, could be. Anybody else disagree? Anybody think something different?
Well, you said they're taken separately.
Taken separately, yeah. So.
I don't think so.
You don't think so? All right, so I think that is the right result. Lewis sued Lee. He disagreed with you, but the judge agreed with you. There are original works. There are slightly different choices made or different components of it. The fog is a little bit less than Lee's image. It has less of a dreamy affect. There's more street. It's not exactly identical, so the court said, no, it's an original work. Lee can use his. Lewis can use his. That's that. There's no infringement. Lewis can't sue Lee. Okay, so when we talk about infringement, generally we're talking about exact copying. Okay, means they ripped you off. Maybe they cropped it, changed it a little bit, photoshopped it. All those things are called derivative works, but they're still ripping you off. You're the only one who took the picture, made the content originally. Okay, similar but original work like what we're talking about, that's not infringing. Okay, unless it's really, really similar. So here's a case: is that a guy did a studio shoot. He had a model that looked a certain way. He did very, very abstract makeup, not something you're seeing on the street, kind of crazy. It's something David Bowie would use in a concert. And then somebody did the exact same background, exact same lighting, exact similar looking model, and exact same makeup. That is infringing, okay? That is more than could happen in independent works, so that will be infringing. And those cases are very fact dependent. Fair use, this is a term that you guys are gonna hear. It's defense to infringement. So somebody uses your work, it's copyrighted, but they say, no, it's fair use, I get to do this, okay? A lot of people say this, don't know what they're talking about, and it is often not an infringement. So the fair use rules are complicated, but basically what you want to look for is issues where free speech is at stake and whoever owns the copyright wouldn't want them to use it, okay? So let's say you got a critic. He's criticizing David's work, okay? David would never sell the copyright to this guy, would never license that, okay? But he has fair use. He gets to say, you're not quite as good as you think you are, okay? Reporting, educational use, and parody. Weird Al, he sees a song, I don't know, am I the only one who knows who Weird Al is in here? Yeah, okay, there we go, all right. So he parodies your song, he doesn't have to ask permission. It turns out he does, but he doesn't have to ask permission. Parody is legit, okay, that is fair use. But if somebody's just reposting your stuff, if somebody's using it commercially, if somebody's making money, or even using it in a way where you could make money, fair use does not apply, okay? That's not fair use. Okay, so one of the things I'm going to talk about, probably repeatedly, is registration at the US Copyright Office. What this means for digital content is you go to copyright.gov/registration, you submit your work in an application, you identify yourself as the author, you pay somewhere between $35 and $55, and then you get a document back that says it's registered, okay? So why do it? We're going to talk a lot about it, but why do it? So yeah, you own the copyright when you create the content, but that doesn't mean very much, okay? The other thing is registration is really easy, okay? You can register, let's say, 750 images for $55 at the same time. And again, I want to come back to this. Your work is your asset. It's not labor you're doing for a client, okay? Maybe you give that asset to the client as part of the deal. That's legit. There are reasons to do that. But maybe you give your client a part of that asset, and the rest of it stays with you for the rest of your life plus 70 years, okay? And the only way to protect that asset as a practical matter is to register it. And finally, we're going to get into some stories, but you can legit make money off of pursuing people who use your work without your use. And I'm talking real money. It's not that hard. People do it all the time, okay?
I'm the question asker, but just for
Sure.
clarity, one more time. In the case of you're working for someone, and like you said, we register the work, you intend for your client to have that work to use as they wish, let's just say for eternity.
Right.
But you want to protect the work from other people taking advantage of that work. Is that protected properly by registering?
Yes. So the first step in protecting that work is registering it, because otherwise you can't do the things we're about to talk to. The second step is making sure that there's a clear license where, for instance, let's say that third party that uses the image that you didn't give permission to, if they got it from your client somehow and your language was too broad and the client was allowed to do that, they may be protected. Okay, so we want to be careful there. But generally, yeah, those third parties, if you're registered, we're talking and we're going after them. Okay, so here's some of the differences. Okay, if it's unregistered, yeah, you own a copyright, but you can't do much with it. So let's say David takes a picture, somebody makes a mouse pad out of it. He's never met this guy, I didn't give him permission. If it's not registered, David has to prove actual damages, okay? Which means he has to say, hey, I could have sold you that license for X dollars. Here's how much you made, which means that I, as his attorney, need to go find the records and dig up everything this guy's hiding. It's a long lawsuit, and you're limited to how much damage, to a monetary amount representing how much damage you actually suffered, okay? If it's registered, we're walking into federal court, we're showing that this guy infringed on the rights, and bang, you're getting somewhere between $750 and $150,000. Okay, it's up to the judge, but you're getting paid. Okay, you don't have to prove how much you lost. You don't have to prove how much money this guy made. It's helpful, but the judge is paying you. Okay, as long as you prove the fact that they infringed, it's $30,000 if it was accidental, up to $30,000, and that limit goes up to $150,000 if you can show that they did it on purpose. And we're going to talk about that. Attorney's fees. If it's unregistered, you're not automatically collecting attorney's fees. If it's registered, I'm also automatically getting paid, okay? Now these two facts together, kind of critical, because what it means is you find your work on the internet, you screenshot that, you come to me. If it's registered, I'm taking the case. I'm dealing with that for you. I'm taking that problem off your hands and you're getting paid. If it's unregistered, I'm not as interested, and no attorney is, because we don't know whether we're gonna get paid, and it's a way more complicated trial. Right? Now we got to prove damages. I got to get into that guy's records. His lawyer's going to be a pain in my ass, okay? This whole thing is so much more effective as a hammer to protect your assets if it's registered. Can you sue lawyered up big companies and win? If it's unregistered, no, it's not happening. Why? Again, the case is more complicated. If it's more complicated, the guy with more lawyers wins, okay? If it's registered, the better their lawyers are, the faster you're getting paid. Why? Because if it's registered, the law's on your side. Those lawyers know we're not messing with this, we're just paying the guy, okay? Because the registration means that the case is so simple for us, it's easier to protect your rights. The better lawyers they have, the easier it is for me to get you paid, okay? Can you sue for an injunction, which means please stop using my image? Yeah, if it's unregistered, you can do that too. But again, you're not getting paid. Can you sue in federal court? Not unless it's registered. And then there's something which is happening December 27th. I'm not going to get into it, but it makes it even easier to enforce your registration. They're creating a new procedure. It's all digital. I can get you paid even quicker if there's an infringement. And then DMCA takedowns, again, you can do that for everybody. So just talking about enforcing your registered work, there's kind of three cases. So there's against third parties, again, that guy David never met who's making a mouse pad. There's against clients who didn't pay you, or they violated your contract, right? Essentially, in a big way, they didn't pay you. Or against clients who, yeah, they paid you, they had a right to use your work, but they exceeded the scope of that license, okay? They used it in a way where they didn't buy that right from you, okay? Those are three different situations. Against third parties, that's where you're gonna get paid in a lawsuit or in a settlement. Look for commercial uses, so some realtor, some blog that's actually a big deal is using it, some travel site, anything that's using your image or your content without your permission. If they're making a product, we're suing them, okay? Look for uses that damage your value. So they associate it with something negative. They're like, we're gonna talk about a case of this where it becomes a meme, where it becomes harder for you to sell that image to another person. Or it's just gets a bad rap, and we'll talk about a case of that. Again, if it's registered, you get statutory damages and attorney's fees. It means I'm taking the case and I'm getting you paid fairly quickly. As soon as you see that, screenshot everything. Okay, we'll talk a little bit more. We need that evidence. All we need to do is prove that they infringed on your right if it's registered. Against non-paying clients. So forget about this whole other thing of going after people you never met. Let's say you produce a work for a client, okay, and they simply don't pay you, right? So now, unless your work is registered, you got to go after them for a contract claim. They violated your contract. Again, long, annoying lawsuit. Maximum damages is the amount of that contract, okay? I'm probably not taking that case. Probably no one's taking that case. Your rights are not protected. If you're registered, though, you now have a copyright claim. They violated your copyright because you only gave them that license if they pay you, right? That's part of your contract. Now you can go after them for even more money than the contract. What's up, bro?
I have a question on that.
Yeah,
too, right?
you now what you have to prove, both in contract and in copyright, is you have to prove that they either violated the contract, and a contract doesn't have to be written down, but I'm telling you to write it down. Like any lawyer is telling you to write down that contract. Well, I'm actually giving a talk about that next week. Please, everybody, have some contract with your clients, okay? And then.
On that note, she's going to take more than an hour because it was great.
Yeah, no, questions are good.
It's cool. But in the event of something like that, what about email chain? Like
That can be used, yeah.
Right, this is what it'll be, this is what your cost is, they agree, okay, come at this time, do
Yep.
this. That's going to be, it's not a contract, but it's a clear indication of intent.
Exactly.
Pay, and there's no knowledge of the cost of the work, etc.
Again, though, you're getting into a pain in the ass lawsuit as opposed to an easy one. So yeah, that can potentially constitute a contract, but it's going to be a legal question.
Right.
Yeah. So, and so can a verbal one. Yeah.
So like that type of agreement is still valid too?
It can be.
Whether it's a thumbs up emoji?
Yeah, it can be. It can be. That can be a contract.
Okay.
But again, the key difference here is if your work is registered, even if you just put the registration application in before you give it to the client, and you say, hey, client, you get a license to use it for X, Y, Z. You get a license for this amount of time, could be indefinitely. But if you don't pay me, your use is a violation of my copyright, okay? We don't have to go to the judge with a contract claim, which is going to take a million years, be super complicated. We now go to federal court or these new procedures with a copyright claim. Way easier. You could end up getting paid more than that contract was worth, okay? Because copyright is just a different world. You maybe had a contract for $5,000, you could easily get paid out 20, okay? Because they screwed you, all right? So again, you have assets that you're creating. It's not just the contract work. Against clients who exceed the scope of your intended use, so David and I talked about this. Obviously, as a business person, you don't bite the hand that feeds you. If you have a good relationship with the client, they go a little bit too far, maybe that's a phone call. Say, hey, I was not comfortable with this. I'm letting you know. I'm letting it slide for now. But it's not, when we have an agreement, you got to stick to that agreement, okay? Sometimes, though, it's a little crazier than that. So I know a photographer, he did a picture of LeBron for a regional use, okay? He's in a bowling alley in, I don't remember where, I forgot I told you, New Mexico, getting ready to fly back to New York. He's watching the Super Bowl, that's why he's in the bowling alley. He sees that same client use that image of LeBron in a Super Bowl ad, okay? He never gave them permission. In fact, they asked him for permission, and he said no. He said, I want 25 grand for that image. They said, a little pricey. He goes, go find somebody else. He got $101,000 from them for their use of that image in this ad, okay? And they hired him again after. You know why? Because they fired the dumbass who did that, and they had a new person hiring the talent, and he was like, listen, you did the right thing. That's your image. You protected it. We paid you because we were wrong. We're hiring you again because you create good content. Okay, that is a true story. So he wanted 25 grand for this image in the Super Bowl ad. He ended up getting 101 plus attorney's fees. So we're doing a new... RJ's blown away. He needs some water. He needs some water. We're gonna talk. That's a real story. So I want you to know, $300 million of copyright money, okay, copyright claims, gets paid every year. And I'm lowballing that figure because there's one case with Sony that was like $2 billion. But on average, at least $300 million of these claims get awarded by courts. That's not talking about the stuff that's settled, okay? That's just awarded by courts. So this is a real thing. This happens, and it happens to people like you, okay? Register your work. We're starting a new thing in my law firm. We're getting it in motion now, so this is kind of the advertising segment. We will help you get your work registered as simply as possible. We will monitor it online for infringement. We'll come back to you. If we see a use of your work that's maybe outside of the scope of what you did, we'll talk about it. We'll figure out, hey, is this a client? Is this something that's okay? And then if we decide together to pursue it, we get you paid, okay? I threaten them, I file the lawsuit, we split the award, you get 60%, I get 40%. So this is for third parties. This is not for the people that you're working with. Obviously, that relationship is something you want to negotiate, but as if we see crazy cases. What's up, David?
I regret breaking you every time.
No, you got good questions.
Real question. Content Factory. Now, because also, my mind is Content Media Factory, but it's Content Factory Media Group. All right. It's a team of people.
Yeah.
They produce work as a team.
Right.
Can they copyright the work as the company, or they have to do it by the individual creator? Because if there are 3 photographers or 3 cinematographers covering something, they make a collective work based on the collective work. How do you handle that for copyright registration, and how do you deal with that moving forward?
So,
is it only the company that can be protected, and so on? Just thought as we're dealing with this.
Great question. Yeah, so there's 2 issues there. So one is co-authorship, okay? Raul and RJ work on something together, okay? And the final product reflects both of their creativity, their initial co-authors, okay? There's another question, which is, what is the legal relationship between these people, okay? So we have the work for hire, the words finally came to me, the work for hire doctrine, okay? So let's say Raul is RJ's employee, okay? We'll talk about this, I'll be able to skip a slide, it's great. So if Raul makes content in the regular course of his work for RJ, and it's an employment relationship, he's not a contractor, it's an employment relationship, then RJ or whatever company is RJ's that Raul works for, that the employer owns the content initially. But there's some big buts. So number one is if you're doing this and like it's not your normal thing to do, okay, you're normally the receptionist, but I took a photo and you're using it, no, that's still mine, okay? It's when your job is content creator. The other exception, which is huge for a lot of people in the room, is when you're a contractor and not an employee. Super complicated question, okay? And it's like a state law. It's one of the most annoying questions in all of American law is who's a contractor, who's an employee. If you're a contractor, unless your contract says otherwise, you're the initial owner of the copyright, okay? Now your contract may say otherwise, right? But unless your contract says otherwise, you're the initial owner of the copyright. You're the author, okay? The corporate stuff, like you guys might be partners in a business, you guys might be co-owners of a corporation, that gets more complicated, okay? But that's one of the other layers there, okay?
Thank you.
No problem. Registration, I'm skipping this. I'm making a YouTube video on it. Bottom line is, that's the URL. It's $55 for up to 750 images or one video. There's some details. The one thing to know is if you're doing this by yourself, do not use Chrome, do not use Edge, use Firefox. Is the only place it works. But I will share a video with you of all the boring details here. You guys are going to go to sleep if I tell you. How to monitor for infringement. OK, check your work on Google Images, right? You can upload pictures. You can just kind of drag it with a mouse. If you've done a studio shoot and you have similar lighting for multiple subjects, or even similar subjects, you've done a party and the background looks the same, sometimes it'll pull up a lot of images from that shoot, okay, if you just upload one. You can do tineye.com. I think that's kind of antiquated. I haven't seen great results from that recently. You can do more complicated things like digital watermarking and tracking services, which cost money. Often they're prohibitively expensive. They're like really expensive. But I think there might be some simpler things out there. And then again, when you see infringement, screenshot everything, okay? When I say everything, I mean screenshot the URL, the web address, screenshot the name of the image that they use, whatever .jpeg, screenshot the source code of the web page if you can, and then come talk to a lawyer, okay? Yeah, source code is really valuable. I'm about to explain why. So how to use the copyright symbol. Most of you are probably familiar with this. The real question is why, but you use copyright, owner full name, or company name if the company name owns it. And then the last year you edited it. Okay, the last year you came back and changed it. So for me, you can use copyright even if you don't register. It just puts people on notice. For me, I get to use my awesome, super lame middle name. So Max Philip Levine, 2021. I copyrighted a bunch of stuff a couple weeks ago. You should also be entering your copyright and contact data through Photoshop or whatever you're using. What is it, Lightbox? I don't remember what the other one is. But there's either easy ways to enter that data in the file, okay? Use watermarks, copyright notices, contact info in the image data. Question is why? Again, if they change the name of that image and it had your copyright data in, if they remove any of that copyright data, that shows intentional infringement of your copyright. The damages on that case just went from $30,000 to $150,000, okay? All they have to do is change the name of the image. So make sure your copyright data is in your images. And here's a case I'm going to talk about. So this guy, his name is Monty Isom. He's a photographer in New York. In 2014, for the World Cup, he did 27 of these pictures with different fans of different countries. This is Portugal. And he put it out there. He sold his work editorially. He's done a bunch of high-level work. He's been on the his shoots been on the cover of Time, Sports Illustrated, all over the place. I spoke with him this afternoon. I asked him permission, and I got it in writing to use this image. And he asked me, he actually has a ton of awesome content on YouTube and on F-Stoppers. He's got a great course about how to actually make money from photography, and he's the guy who knows how to actually make money from photography. So it's good stuff. A couple years later, he finds this image on a blog. And it's a blog about the most annoying soccer fans in the world. It's about douchey soccer fans. That's the title of the blog post. And the guy took this image, and he actually renamed it douchefan.jpg, right, .jpeg, okay? So Monty finds this. He's just searching on Google Images. He's just seeing if any of this work has been used. He knows he's got a case. He screenshots everything. He calls the author of this blog, and he says, hey, we got to talk. You got to remove the image, and you got to pay me. Because now I have this image that I was using commercially, but it's associated with douchebags, okay? I can't sell it as well now. You got to pay me. Doesn't hear back. Writes the guy emails, doesn't hear back. Finally, the guy says, oh, I took it down. Great, you still got to pay me, okay? Doesn't hear back. Monty talks to his lawyer. His lawyer files suit in federal court. Not difficult. 4 hours later, they hear back from this guy, okay? And he says, you know what? You're right. I owe you money, $7,000, okay? Monty says no. He says, here's what I want, $18,500 plus attorney's fees, okay? Why? You diminish the value of the image. It's douche fan now. I can't sell douche fan. Maybe he can, maybe he can't, but he's got an argument. Bottom line is, they found $18,500 plus $3,500 in attorney's fees in less than a day because they talked to a lawyer, and your rights are that clear if you register, okay? He got paid $18,500 for that. He still uses it. The guy in that picture is a friend of his who he now refers to as douche fan, okay? So, by the way, do check out his stuff. It's really good. Let's talk about your relationship with your clients. Okay, so monetizing your work from the people that you actually want to use your work. We're going to talk high level, broad stuff, but there's two options you basically have. In copyright, you got assignment and you got licensing. Okay? You can assign your work or you're going to license it. Assigning means you are selling it. So this is the buyout, right? You heard of buyout of an image. You are assigning your copyright. A little wrinkle there, you can assign the copyright or you can assign one of those 6 rights, okay, or more, right? Licensing means clients paying you to use your right. You still own the right, but the client gets to use it in some way that you delineate in a contract, okay? It can be temporary, it can be partial. When possible, license your work instead of assigning it. Why? Again, life of the author plus 70 years. You have no idea how valuable that image may be, and the client doesn't need it for everything. The client needs it for something. Name that something. Make sure the client is cool with what that something is, but license it for that something. Don't assign your rights in the content if you don't have to. Are there times that you have to? Yeah, maybe you're shooting a wedding, and honestly, I don't know too much about wedding photography, but if you're shooting a wedding and they're weirded out by you retaining your copyright in the images, then maybe you assign them the rights. Okay, maybe you sell them those entire images, but maybe not. That wedding may be valuable for some reason 20 years from now. Okay, let's get into the details a little bit. Work for hire, we already talked about. So assignments, this is a complete sale of one or more of those exclusive rights. Has to be in writing to be valid. Okay, in order to assign your right permanently, has to be in writing. And again, you can do one or more of the exclusive rights or the whole image. So classic example, J.K. Rowling writes Harry Potter, right? She assigns the publishing right to that first book, okay, to the publisher. Publisher says, I'm the only one with that right. I got to make the money off of publishing that book. I'll pay you something for it, but I need that right to be mine. But she retains the other rights, including the right to make derivative works, okay? She makes 5 more of those books and she's a billionaire, okay? Why? Because she assigned one right, but not the whole thing. It's obviously appropriate in certain circumstances, less so in other circumstances. Licensing terms, I'm just going to hit the numbered ones here, but in your contracts with your clients, these are the things that you should take. Take a picture of this, okay? These should be in your agreements. I'm going to make this available to everybody, but if you have a client, you should be real clear about what the grant of the license is. I'll get this to everybody through RJ. What the grant of the license is, so what work is licensed, which rights what they can do with it, any limits on that, so maybe geographic scope for a specific purpose. Maybe you can revoke it. You got to name the price, so it could be a dollar amount, could be a percentage of money that they're making off of integrating your work into something else, okay? If it is that second thing, the percentage, you got to have what's called audit rights, which means you get to check their books and see how much money they're actually making. Because if you can't do that, it's worthless, right? And sometimes you have some kind of quasi like penalty clause, like, oh, if you underpaid me, now you got to pay me 2 times that amount you underpaid me by. Okay, if I had to go look at your books to get paid, then you're paying me extra. You got to make sure they understand what they're not getting. So here's the rights you did not license from me. They're going to want you to make some warranties. So warranties like, yeah, I secured model releases. Yeah, this is my image. I'm not infringing on anybody else's work by delivering this to you. And you know, they may want an exclusive license. Again, you're telling them it's a license, not an assignment. Assignment means they're buying the rights. And you're warning them, if you breach this contract, I'm going after you in copyright. Okay? It means I'm getting more money faster. Okay? Make sure they know that so that they are less likely to breach the contract, more likely to pay you, and they know exactly what's up. You have intentional infringement later on. This is an example just of how you can slice and dice the rights in a license, okay? So a photographer is shooting something for an article in a magazine, okay? This gets really complicated. I don't need to go through all this, but you have cool things like, for instance, the magazine will reserve the right that, hey, we're going to pay you for this shoot, and we're going to integrate it into the article, but if we use it on the cover, right, and it's got Vogue magazine on it, so now your image plus Vogue magazine, that picture with the title of the magazine, that's our copyright, okay? In other words, it's a negotiation thing, like, yeah, you get paid for this work, but if we decide it's a cover shoot, right, it's on the cover, then your image plus the word Vogue, that's ours. You still get to use your image without the word Vogue, but that's how you can slice and dice a license, okay? And there's some interesting things here that they've clearly negotiated very carefully. So there's an embargo. The photographer can't do anything super similar for like 120 days. But if he has somebody who wants to buy that work, the magazine says, you know what? Come tell us. And maybe we'll say yes, and then we'll split the money, okay? So you can really slice and dice these licenses the way you want. And again, that's a really sophisticated one. Very few people need something that complex. Again, like I say, contracts matter a lot. So they make good clients happy because it clarifies how you're going to do the work for them that you're going to do ahead of time, and you can keep those promises, and they know that you're keeping those promises. They protect your rights, and again, because you're creating content, that copyright is so much more important to you than somebody who's just doing a service. And they ward off bad clients. So if you got a clear contract, it's totally fair, it's doing what you said you're going to do, and somebody's hesitating to put their name on that, that's a red flag. Okay, you may not want to deal with that person. So a good, clear contract could be 1 page, could be 4 pages, could be 25 pages. Nobody needs that. That helps your business, particularly if your business is selling content. Last 2 things, and we'll talk questions. Content on Instagram, there's a lot of details here. The terms of service on Instagram give them a right to reproduce your work, right? They get to store it. They get to serve it up to people who are looking at your feed. And you can revoke that license by deleting your content or your account. Instagram does ask for 90 days because it takes them a while to delete everything, or that's what they say. You can't post other people's work without permission, okay? And other people can't post your work without permission. DM them. Just message them. Say, hey, can I repost this? Can I use this? Do you want me to credit you? Do you want what particular hashtag, or do you want me to mention your account? Get that permission in writing before you repost. As we speak, Dua Lipa, Snoop Dogg, and Ariana Grande are all getting sued for reposting stuff without permission, and they are all going to pay, okay? Because it's that simple. If you repost without permission and somebody's targeting you, we had somebody in GP who came upstairs to me with a letter that they got for using Arnold Palmer, the old golfer's image, right? Arnold Palmer was right, he was wrong, okay? If Arnold Palmer wanted that money, he was going to get it. And that's what I had to tell this guy, okay? So be careful about that. DMCA, so you guys have heard about takedown notices, this kinds of stuff. You can go to Instagram if somebody's using your stuff without your permission, and you can say, hey, you can fill out a form, I want this stuff taken down, and they will review it, and if it's a valid claim, they'll take that stuff down. What it really means is you can't sue Instagram and YouTube for someone else uploading your stuff. It protects them, not you, okay? So it's not the greatest law in the world, but you can kind of understand it. YouTube wouldn't work, Instagram wouldn't work unless they had this protection. But at the same time, it means they're not liable for broadcasting your work against your rights all across the world. You only use this when your work isn't registered, when the person uploading it is broke, or when it's a seriously non-commercial infringement that you don't care that much about, you just want it to stop, okay? So that's it. That's the basic overview. All this stuff is going to be posted on maxlevinelaw.com. I got a blog up there. I'm going to put in kind of less sleep-inducing, bite-sized, videos. And I do office hours every other Thursday here. So you can just walk in. We'll spend 15 minutes together if you're a GP member. Reach out to me if you want to just talk. I do workshops. I'm giving another talk again next week on contracts. And I'm just Max Levine Law on Instagram. So that's it for me. You guys got questions? Let's talk. We got a little time. I know David's got to go soon. So, thank you. Anything we didn't talk about? You guys want to address?
I got one.
Okay, RJ starts.
All right. So, say for instance, you doesn't work with a client, and they pay a deposit, do the whole entire work, the whole editing it, the whole entire work that it costs to do the project, that everybody that it costs to do a project, and you at the finish line, and now they're like, oh,
Change your mind completely.
Yeah.
I'm good.
Are they using it?
Yeah.
Not yet.
Well, not yet.
Okay. You think they're going to?
They may.
Okay. So we got 2 issues. So one is a potential a breach of the contract. Okay. So you got to go back. What agreement do we have in place? Again, could be a set of emails. Hopefully it's a piece of paper. All right. And if your piece of paper is now a product of your mind and my mind, okay, what do we come up with and say is going to happen in that situation? Again, though, that's a contract claim. Okay, contract claim is a little tricky. Maybe a call from me does it. Maybe, hopefully, a call from you say, hey, we agreed about this. What happens if we get to the finish line and you don't like it? You pay me 2/3 of what's left, right? Hopefully, that's in your contract. If it's not, we got to kind of figure out what's going on. The other issue is copyright. If they use the image, now you have a copyright claim. If they just walk away from it, right, they didn't violate your copyright. But if they use your image in any way, and particularly if it's registered, like run, don't walk up to my office, okay? Because now we're getting you paid for sure, all right?
So as long as make sure it's registered.
Make sure it's
As long
registered.
as they don't use it.
If they don't use it, you don't have a copyright claim.
Okay.
But what the main situation for you is going to be contracts. You have enough experience where you can kind of see around the corner and say, hey, here's what we're going to do if you walk away and I've done all the work. You're going to repay me costs and 1/2 of the remaining balance, okay? And you're going to put that in the contract from day one so that they get that. If they've approved the work and you did all the editing, the post, all that stuff, and then they just walk, yeah, they got to pay you under contract law. It's a little bit, again, it's not as easy to pursue as a copyright claim if they use the image and you've registered, but you still got a hammer, right? You still got some way to enforce those rights. Yeah. All right, good. Anybody else? Talk.
A little off, but I missed the slide where you said what you went to school for. I have a friend that's doing entertainment law.
Yeah.
Curious.
Yeah, entertainment law is a lot of contracts and it's a lot of IP as well. And it's being an agent. That's what it really comes down to. So yeah, that's the, what is it, Jerry Maguire, right? That's the Jerry Maguires of the world. Those are entertainment lawyers. Yeah. Anybody?
I saw something up there about intellectual property.
Mhm.
I heard that word before, but I don't know what it really means.
Yep.
Can you explain that?
Absolutely. So intellectual property is like the category above copyright. So intellectual property includes patents, which we talked about for a second. Like you got some process, some invention. It doesn't have to be physical, but you can patent that idea. It means ideas that you have rights to. So books, photographs, those are copyrights. It also includes trademarks. So like a logo or a name, McDonald's is trademarked, right? The word and their symbol. And then it includes something which is trade secrets, which means like Coca-Cola. The recipe to Coca-Cola, there's no patent, there's no trademark. It's in a vault. You can see the vault in Atlanta, okay? That's a trade secret. That is protected. If any of their employees go and tell it to anybody, they get sued for the next 2 centuries. So those are the things that are called intellectual properties. A few other little backwaters, but those are the main things. Trademark, trade secret, patent, copyright. That's the main thing. What's it?
To go a little further in that.
Sure.
With the intellectual property, I know that one of the, like you said, is about an idea. So say for instance, I have someone that I sat down and I gave them an actual idea, but they didn't use me for that, but they go use someone else. That
Right.
would be considered something I can kind of go after them about.
And so it's going to be really difficult. So it's not, because there's no specific thing, right? You didn't take the picture or create the content. You don't have a copyright claim. Patents need to be applied for in order to get that protection. You'd have to make the claim under like trade secret, but because you told them, right, it's not such a secret anymore. So it's really difficult. In those cases, what you want to have is when you're going to be creating some concept for them, and a lot of the value of what you're offering is that idea, you want to have like a non-use and non-disclosure agreement very early on. Say, hey, we're talking about stuff. Maybe you don't go forward with it, but if we disengage, if we stop talking, then you can't go forward with anything we talk, okay? And that's the non-use and non-disclosure. You can't tell anybody else because it's my idea. I'm willing to work with you on that if I get paid. But at this stage, I want a non-use and non-disclosure agreement. And I've negotiated that for directors and producers where they're talking at a high level of creativity, but they got to be protected when they're talking at those levels because somebody might just run away and do the same thing, okay? So that's important. It's harder to protect, but it is important. Yeah.
I'm still on this intellectual property.
Okay.
Something like raw images and raw photos.
Yep.
Something that you use to create the final product, right? So it's like I feel like that's intellectual property as well, and that's not something that you give out. So even with the example with Coca-Cola,
Right.
the recipe, that's like my example of raw footage and raw images.
Right.
That's just the tools I use to create that final product for them.
You could protect the raw images as trade secrets. That's possible. But it's easier, cheaper, and more effective to protect them as copyrights. Because again, let's say you register the raw images. Now, whatever you do to Photoshop them or whatever file format it goes to in the client, that's a derivative work. You own that right too. Okay. So if you've copyrighted those raw images, or really even a tiny version of them, that's the best protection you have with regard to images. You could protect it as a trade secret, but that's really complicated, really expensive. Generally, you don't want to do it. The only reason Coke doesn't do it, by the way, is because the patent would run out, right? Patents, like copyrights, have a life. They end. And Coke would have to tell everybody as part of their patent application what their recipe is. They don't want to do that, okay? So it's the biggest trade secret in the world is the recipe to Coke. That's the famous example. But they have to do crazy things to protect it. So, what's up, George?
No, I just think it's wow.
Yeah, it's crazy. It's literally in a vault in Atlanta. You can see it. So it's in the Coke Museum.
So one way I was thinking maybe if I wanted to have my idea be secure, is it possible if I say for instance I have a client or whatever and I just be like, hey, I'm about to record us having this conversation, is that possible?
That helps you show exactly what you talked about. And I think if they're comfortable with that, then great. You know, that does. But you really want that agreement in place that says, hey, unless we go forward, you can't use these ideas and you can't tell them to anybody else. It's that agreement that's going to protect you. And then that audio recording is going to be the evidence that proves what's protected. Okay? You know? So producers have this problem all the time. You get, beat licensing and they'll show it to somebody and then somebody does something super simple or super similar. That's a common issue. I'm here. You can hit me up on Instagram. You can hit me up on the GP Slack. There's a form on my website if you want to contact me. I'm happy to talk to anybody if you have questions. If it's something super simple I can help you with, I'll just help you for free. If it's something where you really need representation, I'm here for you as well.
Something super simple, you're going to help us for what?
For free. Yeah, I do that, David. I do that.
I wasn't recording.
RJ is. So that's what I got. So thank you guys for listening. I really appreciate everybody coming out. And RJ, obviously, thank you so much for the opportunity.
Oh yeah,
as always.
man. You killed it, man.
Thank you.
Appreciate it. So you got